Judge Evander,
what's your response to opposing counsel's argument that given the trial judge found that there was not a willful and deliberate attempt to not produce the explanation of benefits, that it was inconsistent to then impose the sanctions that the trial judge did?
Okay. The case that I've cited in my brief from this court makes it very clear that there is no magic language. You don't have to say willful and deliberate. It has to rise to that level, but you don't actually have to call one of the parties out and say you willfully and deliberately withheld this evidence. To understand what this was.
But here there wasn't an omission. I mean, the judge made a finding that he could not find willful and deliberate.
Yes. Yes, sir. But what the judge was required to do, and this was well briefed by both parties in the pretrial motions, the judge was required to examine all the facts of the circumstances. The judge was required to weigh and consider all of the options that he had available to him. And the judge was required to enter a written order and a ruling defining why he chose the path that he chose and why he excluded certain others. That meets his requirement to demonstrate that he is using appropriate discretion in this situation, and it insulates him, if you will, from being called on abuse of discretion. He did all that. He satisfied that. To not give effect to Judge Mull's decision at the trial is tremendously impactful to all trial judges, because it says to them, regardless of the decisions that you make, you with boots on the ground, seeing the witnesses, deciding the case, making the decision how to run your court most efficiently, regardless of the decision that you make, we're going to second guess you. And that is not really fair to Judge Mull. He lamented for quite a while over what would be the appropriate response. And Judge Berger, you pointed out, I believe, whether it was, I'm sorry, Judge Evander, you mentioned earlier that was a possibility that costs could have been paid for our expert, that attorney's fees could have been paid. Judge Mull examined all that. And what he found was this case had been delayed significantly for quite a while. We were right on the eve of trial, that to delay it further would be inappropriate and work an injustice on both sides. There would have been more cost involved, he found, and he really went through these at great length, both at the hearing and in his order. It would have been more expensive for us to have to come back and put on proof of the costs and the fees and everything, and it wouldn't have solved anything. Really what happened, when you look at the forest for the trees, throughout this approximately 2 years of litigation, Florida Cardiovascular maintained this counterclaim that my clients had not turned in some kind of records that they were supposed to, and therefore Florida Cardiovascular didn't have the documentation necessary to submit to the insurance company so they could get reimbursement. They claimed $356,565 in damages and testified in deposition, Patty Reisinger specifically, and in response to not one but 2 interrogatories and 2 requests to produce, that they did not have any documents to support that number because they did not submit any of this stuff to the insurance companies because it was too late when they discovered it and it was past the time to do so. Then, about a week before trial, these documents that were sent to insurers and paid by the insurers magically show up in the hands of this expert witness who's testifying about these EOBs. It was critically important for my clients to be able to demonstrate that Florida Cardiovascular got nearly all of the money it claimed from the insurance companies. It was an outright fabrication for Florida Cardiovascular to say they didn't get paid at all. Those documents showed that they did, and they had them in their possession. Judge Mull grilled Patty Reisinger, the office manager, while she was on the stand at this hearing and asked her where these things were, when she had them, when she discovered. She said the whole time they were sitting in her file cabinet in her office, and she knew what they were. They never turned them over because if they turned them over, it would have dispelled their entire damages case, and we would have been able to wipe that thing out and show that they had no damages. This $12,000 to $18,000 number was a guesstimate that was put on it as to sometimes not all the money is paid. If you claim $100, you get $98 from the insurance company, so there may be a little margin for error there or something like that. But what Judge Mall did when he assessed what would be a fair response is he looked at all the options, and because I left in the first two affirmative defenses, which were the breach claims, Judge Mall said that would be fair because Florida Cardiovascular could still put on evidence of the alleged breach by my clients of these employment agreements. Therefore, we would still have the same issues in the case. It would just remove the damages and it would be fair. What happened through the trial process, which puts us in the position we are today, is that Judge Mall found that there was no breach. There was an allegation, and Judge Mall in the record was very clear with Appellant's counsel as to specifically what was their breach claim, what were the components. And they said the Rouse violated administrative rules. They did not turn in these records to the hospital, to Florida Cardiovascular, and Florida Cardiovascular could not bill the insurance companies. Florida Cardiovascular had the opportunity through its first and second affirmative defenses at trial to put on any evidence it wished to prove what these administrative procedures were. They didn't because they had none. In fact, Judge Mall found in his final judgment that they had the opportunity to make administrative rules, and they didn't. They had no administrative rules that could have been violated. Second, the evidence at trial also showed that Patty Reisinger was going to that cath lab and picking up on a weekly basis all of the records showing the work that my clients were doing. So even if they hadn't turned something into Florida Cardiovascular all along knew exactly what my clients were doing because they were picking these records up from the lab at the hospital at which they were working. Judge Mall found that there was no breach of the agreement on the part of my clients. So therefore, because you have to have breach and damages, if you don't have the breach, you never reach damages. That's why I said in my brief that if the court for some reason would find that this was too severe and it would override Judge Mall's discretion, what would happen is it would go back to the trial level and those facts remain static. The trial court is just going to simply find that there was no breach of the contract by my clients, so therefore we never reach damages. So Florida Cardiovascular has not been prejudiced in any way. So it becomes kind of an academic issue. But I do feel, based on what is in the record, that Judge Mall did his best. He really tried to give a balance back to the situation. He went through, both at the hearing and in his written order as he's required by law, all of the options from weighing the awarding costs, attorney's fees, doing other actions, not allowing certain evidence in. And he felt in his discretion, his sound discretion, the best way, as he said, to rebalance the situation on the very eve of trial was to strike the counterclaim, which literally just took out the damages portion. They still had the opportunity to put on evidence of breach, and they couldn't prove breach, and he found that they didn't prove breach.
Any questions? Thank you.
Thank you, Your Honors.